COPWATCH, policing the police every single day.
Say hi, Andy. I'm recording you.
Alright, you get the whole thing, right?
I got you.
Ocean City cops are not people.
Yes, they are. You know what's really criminal?
What's that?
Those knee-high socks.
I know, but that's what the brown shirts wore.
See qualified immunity. One additional factual background. In his complaint, the allegations of which this court must accept as true, plaintiff avers the following: on the day of the incident in question, he was standing near a public highway, video recording himself holding up 3 signs while periodically swapping between them. Document 3 at 5. Case 3:20 CV03677 NBK Document 26 filed August 25, 21 page 5 of 15 page ID 132. 6. Plaintiff signs read: 1. Well, the system isn't gonna fuck itself. 2. Shit is fucked up and stuff. 3. Give me liberty or give me death. And 4. Free food, potatoes and carrots, which was written on the back of one of the signs. Point 4 Document 3 at 5:12. Approximately 15 minutes into plaintiff's peaceful demonstration, Officer Dial arrived at the scene and approached him, having been dispatched due to a complaint of a man holding a sign, namely the second sign quoted above. Document 3 at 6-7. Officer Short and another officer also were dispatched and arrived on the scene. Document 3 at 7. Defendants laughed about the sign, but Officer Dial subsequently attempted to coerce plaintiff to consent to a search of his other signs, which plaintiff refused, at which point Officer Dial attempted to forcibly seize the signs over plaintiff's objections. Document 3 at 7-8. When plaintiff invoked his Fourth Amendment rights, Officer Dial became angry and punched the signs out of plaintiff's hands onto the ground. Document 3 at 8. In the meantime, Officer Short examined plaintiff's video recording screen, then turned plaintiff's tripod-mounted camera 90 degrees away from the scene, thereby preventing plaintiff from collecting content, including evidence of police misconduct and brutality, and as a means to punish plaintiff for his speech. Document 3 at 13-16. Officer Dial subsequently arrested plaintiff. Document 3 at 26-27. Plaintiff contends Officer Dial baited the plaintiff's sick free speech demonstration by violently punching with a closed fist a peaceful protester and seizing from the plaintiff's possession political placards with messages critical of the system. Document 3 at 9. Plaintiff asserts he is a syndicated journalist known for broadcasting and/or publishing content about. 4 pictures of the signs can be found on page 5 of the complaint. Plaintiff alleges that the incident also was captured on defendant's dash-mounted cameras. Document 3 at 7. Case 3:20 CV03677 NBK Document 26 filed August 25, 21 page 6 of 15 page ID 133. 7. Police abuse and government corruption. Document 3 at 9. He alleges that Officer Dial's attempt to suppress his speech was motivated by a desire to punish plaintiff for his speech critical of government misconduct, and he fear of being subjected to police brutality would chill a person of ordinary firmness from engaging in similar protected speech conduct. Document 3 at 11-13. Plaintiff further alleges that Officer Dial's taking his signs and recording device and arresting him constituted content viewpoint censorship and retaliation for his viewpoint and speech, both in violation of the First Amendment. Document 3 at 3-4, Document 3 at 30-32, 35. As for Officer Short, plaintiff contends that his actions constituted a prior restraint, recording interference, a violation of his right to petition the government for redress of his grievances, and retaliation for plaintiff recording acts Officer Short knew had the potential to be used as evidence against him and his fellow officers. Document 3 at 36-39, 43-47. The court will address each claim in turn. 2. First Amendment. The First Amendment of the United States Constitution protects an individual's right to freedom of expression through speech and public assembly. Virginia v. Black, 538 U.S. 343, 358, 2003. This constitutional guarantee prohibits the government from punishing the use of language that is not within narrowly limited classes of speech. Chaplinsky v. New Hampshire, 315 U.S. 568, 571, 1942, see United States v. Alvarez, 567 U.S. 709, 717, 2012, noting that content-based restrictions on speech generally have been confined to a few historic and traditional categories of expression long familiar to the bar, including obscenity, defamation, speech integral to criminal conduct, so-called fighting words, child pornography, fraud, true threats, and speech presenting a grave and imminent threat the government has the power to prevent. At issue in this case is the Case 3:20 CV03677 NBK Document 26 filed August 25, 21 page 7 of 15 page ID 134. 8. Fighting words category, namely those which by their very utterance inflict injury or tend to incite an immediate breach of the peace. Chaplinsky, 315 U.S. at 572. I. Officer Dial. It has long been held that even vulgar or profane language, such as that involved here, is protected unless it amounts to fighting words. Wiegand v. Seaver, 504 F.2d 303, 306, 5th Sir 1974, quoting Chaplinsky, 315 U.S. at 572. For example, in 1971, the Supreme Court overturned the conviction of a defendant for disturbing the peace by offensive conduct after he walked through a courthouse wearing a jacket bearing the words "Fuck the draft." Cohen v. California, 403 U.S. 15, 20, 26, 1971. The court held that, without a more specific and compelling reason, the conviction could not be upheld because the phrase did not constitute fighting words under the circumstances. CID at 26, absent a more particularized and compelling reason for its actions, a state may not, consistently with the First and 14th Amendments, make the simple public display of a four-letter expletive a criminal offense. As pertains to this case, Officer Dial is not entitled to qualified immunity if plaintiff's right to display his signs was sufficiently clear such that any reasonable official would have understood that what they were doing violated that right. Reichel v. Howards, 566 U.S. 658, 664, 2012, stating a constitutional right is clearly established such that every reasonable official would have understood that what he is doing violates that right. Cleaned up. In light of the binding and long-standing precedent discussed above, any reasonable officer in Officer Dial's position should have known that actively preventing plaintiff from displaying his signs violated plaintiff's First Amendment rights. Accordingly, Officer Dial is not entitled to dismissal of plaintiff's First Amendment claim. Officer Short. The gist of plaintiff's allegations against Officer Short is that, at some point during Officer Dial's interaction with plaintiff, Officer Short moved plaintiff's camera away from the scene to prevent further filming due to plaintiff's viewpoint and the content of his messages. Document 3 at 8. Plaintiff maintains that Officer Short's recording interference prevented him from collecting and publishing newsworthy content. Document 3 at 8, 13-15. The First Amendment prohibits the government from limiting the stock of information from which members of the public may draw. Turner v. Lieutenant Driver, 848 F.3d 678, 688, 5th Sir 2017, quoting First National Bank of Boston v. Bellotti, 435 U.S. 765, 783, 1978. There is both a right to gather news by lawful means and a right to receive such information and ideas. ID. Citations omitted. Relevant here, The First Amendment protects film as a medium and the act of filming, as there is no fixed First Amendment line between the act of creating speech and the speech itself. ID at 688-89, quoting ACLU v. Alvarez, 679 F.3d 583, 596, 7th Sir 2012. Moreover, the filming of police officers performing their responsibilities in a public place fits comfortably within basic First Amendment principles, but may be subject to reasonable time, place, and manner restrictions. ID at 690, noting that, among other reasons, such filming contributes to the public's ability to hold police accountable and ensures that officers are not abusing their power, some alterations omitted. In light of the case law discussed above, it was clearly established at the time of the incidents underlying the suit that plaintiff had a First Amendment right to record the events at issue as long as he was doing so lawfully. ID 687-89, further holding that prior to the court's decision issued on February 16, 2017, an individual's First Amendment right to record police was not a clearly established right. See also Gray v. City of Denham Springs, No 19-00889 Batch. Case 3:20 CV 03677 NBK Document 26 filed August 25, 21 page 9 of 15 page ID 136. 10. EWD, 2021 WL 118-7076, at *7, 9, MDLA March 29, 2021, citing Turner in denying motion to dismiss plaintiff's claims for First Amendment violation and retaliation stemming from his peaceably filming a traffic stop in December 2018, after which officers grabbed his cell phone, tried to delete the video, tackled him, and pepper sprayed him. Caldwell v. Medina, No 1:19 CV 524 RP, 2020 WL 404-3501, at *1, 11, WD Texas July 17, 2020, holding that Turner was clearly established law on February 9, 2019 when plaintiff filmed police, CF Durant v. Gretna City, No CV 19-147, 2020 WL 263,669, at *25, EDLA January 17, 2020, finding no clearly established constitutional violation because plaintiff's videotaping the police while detained and handcuffed in the rear seat of a police vehicle was factually distinguishable from Turner. With this precedent, the undersigned finds the law was sufficiently clear at the time of the incident at issue that every reasonable officer would have known that conduct like Officer Short's would violate the First Amendment. Reichel, 566 U.S. at 664, citation omitted. Accordingly, Officer Short is not entitled to dismissal of plaintiff's First Amendment claim. Retaliation. The First Amendment prohibits not only direct limits on individual speech but also adverse governmental action against the individual in retaliation for exercising that right. Keenan v. Tejeda, 290 F.3d 252, 258, 5th Sir 2002. Thus, the First Amendment is violated if an individual is arrested in retaliation for exercising his right to free speech. Nieves v. Bartlett, 139 SCT 1715, 1722, 2019. If an official takes adverse action against someone based on that forbidden motive, and non-retaliatory grounds are in fact insufficient to provoke the adverse consequences, the injured person may generally seek relief by bringing a First Amendment claim. ID, quoting Hartman v. Moore, 547 U.S. 250, 256, 2006. To survive a Rule 12, b. 6, motion, plaintiff's First Amendment retaliation claim must allege, 1. He was engaged in Case 3:20 CV 03677 NBK Document 26 filed August 25, 21 page 10 of 15 page ID 137. 11. Constitutionally protected activity. 2. Defendant's actions caused him to suffer an injury that would chill a person of ordinary firmness from continuing to engage in that activity, and 3. Defendants would not have taken such action but for plaintiff's exercise of constitutionally protected activity. Batyokova v. Doga, 994 F.3d 717, 720, 5th Sir 2021, citing Alexander v. City of Round Rock, 854 F.3d 298, 308, 5th Sir 2017. Officer Dial. Against this legal framework, it is apparent that plaintiff's First Amendment retaliation claims withstands Officer Dial's Rule 12, b. 6, challenge. Plaintiff alleges that, 1. He was engaging in protected political activity in the form of a peaceful demonstration on public property, document 3 at 9, 2. Officer Dial forcibly took plaintiff's signs and ultimately arrested him, document 3 at 7 to 8, 3. Officer Dial's intent was to punish and retaliate against plaintiff for his speech and viewpoint critical of government misconduct, document 3 at 3 to 4, document 3 at 30 to 32, and 4. He fear of being subjected to police brutality would chill a person of ordinary firmness from engaging in similar protected speech conduct, document 3 at 11 to 13. That is sufficient to state a First Amendment retaliation claim at this stage of the proceedings. See Alvarez, 567 U.S. at 717, City of Houston v. Hill, 482 U.S. 451, 463-64, 1987, stating that the freedom of individuals verbally to oppose or challenge police action without thereby risking arrest is one of the principal characteristics by which we distinguish a free nation from a police state. The law has long established that arresting an individual for publicly displaying vulgarities, like here, violates the First Amendment. Cohen, 403 U.S. at 20. Indeed, the Supreme Court recently held that a public school violated the free speech rights of a cheerleader by suspending her from the team after she posted an image on social media with her middle finger raised bearing the caption "Fuck school, fuck softball, fuck cheer, fuck everything." Monoy Case 3:20 CV 03677 NBK Document 26 filed August 25, 21 page 11 of 15 page ID 138. 12. Area SCHDISTVBL by and through Levy, 141 SCT 2038, 2043, 2021, stating that plaintiff uttered the kind of pure speech to which the First Amendment would provide strong protection. See also Eachus v. Steelman, No 4:20 CV 00324, 2021 WL 857988. At *14-15, ED Texas March 8, 2021, holding that police officer was not entitled to qualified immunity after arresting plaintiff who told him to get the fuck out of my house after he unlawfully entered her home and threatened to take her to jail. Brown v. Wilson, No 1:12 CV 1122 Day, 2015 WL 416-4841, at *5. WD Texas July 9, 2015, denying qualified immunity to officer who arrested plaintiff for giving him the middle finger while driving by. In light of this long-standing precedent, Officer Dial's actions were objectively unreasonable. 5 Reichel, 566 U.S. at 664. 2. Officer Short. Plaintiff's allegations against Officer Short obtain the same result. Briefly, plaintiff complains that Officer Short intervened to prevent plaintiff from filming his peaceful protest and subsequent interaction with defendants because plaintiff's speech was critical of the government and he attempted to document police misconduct. Document 3 at 13 to 15. Plaintiff asserts that he fear of being subjected to police brutality only to have one's deliberate gathered evidence thereof tampered with or destroyed would chill a person of ordinary firmness from engaging in similar protected speech conduct. Document 3 at 8, 15. In analyzing whether a constitutional right was clearly established, a case directly on point is not required, but existing precedent must have placed the statutory or constitutional question. 5. In the First Amendment context, if probable cause for an arrest existed or if a reasonable officer could have believed that it did, the officer cannot be held liable for retaliation. Keenan, 290 F.3d at 262. In the present case, however, plaintiff does not specify in his complaint what he was arrested for. Thus, the undersigned cannot assess probable cause at this stage of the proceedings, and plaintiff's retaliation claim should not be dismissed. Case 3:20 CV 03677 NBK Document 26 filed August 25, 21 page 12 of 15 page ID 139. 13. Beyond debate. Ashcroft v. Alkid, 563 U.S. 731, 741, 2011. At least as early as 2016, the Fifth Circuit held that individuals who protest are protected under the First Amendment from retaliatory actions by government officials. See Allen v. Cisneros, 815 F.3d 239, 244, 5th Cir 2016. Moreover, as established supra, plaintiff had a right to record his interaction with defendants. See Turner, 848 F.3d at 688. Accordingly, he had a concomitant right to be free from retaliation for both activities. Keenan, 290 F.3d at 258, the First Amendment prohibits not only direct limits on individual speech but also adverse governmental action against an individual in retaliation for the exercise of protected speech activities. Officer Short's motion to dismiss must fail on this count.
Dude, get the bullhorn out of my face. Hey. He damaged my hearing doing that.
Shut up.
He damaged my hearing. Now I can't, really, I can't say he just damaged my hearing.
I've been watching you. You're out here causing this problem.
This is legally protesting. You should be ashamed of yourself for being un-American.
Come on. Where's your car at, Andrew?
Dude, I am legal.
Where's your car at?
Don't fucking touch my
Where's
son.
your car at?
Dude.
Go to your car. Go to your car.
I am legally protesting.
You don't want that in front of little kids.
I am legally
Let's
protesting.
Let's go.
Dude, you're violating my civil rights?
Take it up with the court.
Did you hear him say this?
Care. Go ahead.
Did you hear? Dude, get the fuck out of my space, man.
Where's your car?
Get the fuck out of my space.
Get away from the kids.
I can fucking leave.
Let's go. Let's go.
Dude.
Go to your car. Wherever your car is.
Hey, Anthony, can you get the supervisor?
Go to your car.
Get the supervisor. He's touching my shit.
Go to your car.
He's touching my shit.
You're not going to harass these kids.
This is not harassing. This is.
You're stopping traffic.
I am not stopping traffic. Bullshit.
Go.
I am legally protesting.
Then protest away from the school.
I can quit fucking touching my shit, man.
Let's go.
I gotta shoe. I gotta shoe.
Get your shoes. Get your shoes. Come on. Let's go. Let's go. Let's go.
And you're telling me to leave. Why?
I'm telling you because you're causing a disturbance.
I am not.
You're stopping traffic.
I did not.
I'm not here for no reason.
I did not. I did not.
Watch the pole. Watch the pole, Andrew.
I did not.
Andrew, don't call me cop. It's Detective Delgado. You got it on your camera. Let's go. Come on.
Quit fucking touching me.
Get away from here.
Fuck you.
I don't care. Whatever. You think that's going to hurt me? Watch the poles. Let's go. Let's go. You're not going to be over here terrorizing these kids.
Terrorizing?
Come on. Let's go.
I am fucking waiting for people, ass fuck.
You're not going to terrorize these kids. You protest all you want over here, but you're not going to be in front of that school.
Seriously?
You heard me? You got me on camera? What, you think I'm worried about that dog on camera?
Wow.
You really think I don't care about that camera? Let's go. Go to your car.
Wow.
Wow, nothing. Don't go back to that school.
I'm trying to cross the street and you are fucking assaulting me, ass.
Whatever. Hold on. Let this idiot cross.
Wow, you're the one that's a fucking Nazi.
You don't even know what it is to serve.
Oh, for the founding fathers, you stupid.
here.
Fuck
Go.
you.
You're out of here. Get out.
Fuck you.